welcome you to New York. Thank you for being here. It's another interesting week as we start doing the downturn from summer into fall, and it's going to be, I think it's going to get real crazy real fast here, friends, in the next little while. Thank you for being with us on AFA Today. Kevin McCullough, always happy to have you with us. I told you last week that there are going to be more and more battles between the people that I'm calling the advocates for sexual liberties. It's kind of a new stated kind of form of what they're calling constitutional liberties that people are finding. I don't find them in the Constitution at all, and I don't think that they have any constitutional basis. But at the end of the day, that's not going to matter. Because if you get enough judges and enough legislators and enough people who are famous on TV and so forth saying that they are, then the masses will go along. Well, I guess this is the way it's supposed to be, and it doesn't matter what the facts are. What are you talking about, Kev? I'm talking about sexual liberties and the head-on collision that they are on course for with in terms of religious liberties. The two of them bashing into each other, and I believe we're going to see that in a very harsh way very, very soon. And we've got several stories that touch on this today. If you go over to onenewsnow.com, you will see very easily that a number of the headlines that are there have to do with moral choices and religious belief versus the idea of uninterrupted, non-criticized sexual expression. And there's a story there today, in fact, about what New Yorkers are going to face if Christine Quinn becomes mayor here in the city. She wants to push the morning after pill for 11-year-olds. She wants to, of course, she's never going to need the morning after pill because she's a lesbian who married her longtime partner. But at the end of the day, she's not going to have any need for the morning after pill, but yet she believes it's incumbent upon New York to make this available to every 11-year-old in the city without, let me emphasize the word there, without any hint of parental notification or permission. That's how really bad that it's gotten in some places in America. But it's even worse than that, friend. It's even worse than that. There's this story on the AP today that describes what churches are now going through in light of what happened with DOMA and Prop 8. And more importantly, what happened last week with that photographer in New Mexico, and you heard about the baker, I think it was in Minneapolis and some other places where businesses have been harshly rebuked by the courts for not catering and coddling those of homosexual behavioral expression. And so there's this fear that they are going to see this behavior, this attempt to sue people that do not want to service homosexual couples. They are afraid that they're going to see this same expression against those people come to the local church. And so the Associated Press story today that deals with this basically describes the plight of several churches in America that are deciding to change their bylaws so that they can say when homosexual couples come to them, will you marry us? No, we have a specific bylaw that says we can't. They're actually hiring, churches across America are hiring lawyers to see to it that this goes into effect. And here's the bottom line, friend, and this may be like really, really harsh to understand or to appreciate today. It may not even matter. It may not even matter because there's a story out of England today. I believe it's in the Guardian, so the Guardian or the Telegraph, whichever one, or the Daily Mail, maybe the Daily Mail, but one of those three. One of the major newspapers has a profile of this kind of postcard gay couple that have been the postcard for all of the gay movements. They were the gay adoption couple that they trotted out there, and they showed the world, oh, look how normal these two men are, and why shouldn't they have kids? And I mean, besides the fact that they can't make them, why can't they have kids? And then they turned that non-baby making system into a business for themselves. They actually run a surrogacy center in London. But this couple that was featured in this prominent British newspaper is desiring to sue the Church of England for the right to have a wedding in the Church of England, even though the Church of England's doctrinal statement will not allow this to occur, even though the practice of the Church of England for all these years has not allowed this to occur. They are pushing for this exception to be made. And friends, here's what they're doing it in spite of. There was what was called a quadruple lock built into the legislation that London eventually passed as the law of the land for the United Kingdom in terms of recognizing gay marriage. And one of the pieces that had to be in there was that there was no way that the Church of England, the Catholic Church, or any other bodies of worship could be forced to perform same-sex wedding ceremonies in their facilities or as a part of their natural function as a church. And so there was specific language that was put into the law that said this will ensure that people of religious faith that have a problem with homosexual behavior will never be forced to participate in one of these ceremonies as it violates their deeply held, sincere beliefs. Friends, we saw judges in New Mexico just last week do exactly the opposite. They said to this photographer, look, it's your price of citizenship. If you want to be an American, you have to perform the photography needs of this gay couple. They can't go elsewhere and find another photographer. You have to be the one that does it. Friends, the liberties of those that live for the desire to express themselves sexually are running counterintuitive and head-on into those that believe deeply held fundamental beliefs about themselves, about the Bible, about God. And the Constitution protects one of those groups in law. It protects those that believe religious beliefs. The Constitution doesn't protect hedonists. It doesn't protect people based on sexual behavior. But it does protect the innate rights of every individual. And so what you have today, churches going, better take care of this. And they're doing it, and they're being mocked by the critics going, oh, it's not necessary for you to change your bylaws. That's not really necessary. Meanwhile, in England, where the law was quadruple locked from having a barrier between a church's right to refuse to marry a gay couple and for gay couples to then marry in a civil sense, they are saying they're being discriminated against because they are, quote, practicing Christians, and they want their children. Well, it's not really their children. It may be children that one of them contributed something to, but it's like partly someone else's child too, if we want to be like really, I don't know, specific about it. But the children that they have in their home, that they are pretending are theirs and raising as theirs, they want those children to witness them be married in a church because of their, quote, Christianity and why it's necessary for their kids. So they're arguing under the law, you're preventing me from being allowed to marry, therefore you're infringing upon my rights by not allowing me to marry in the church. Private church, by the way. Church of England's not so private, but private churches will be held under this same scrutiny. 888-589-8840. This is the reality we wake up with, friends, on this Monday, and it's not a pretty one, I grant you that. 888-589-8840. Maybe you are pro-homosexual. Maybe you are, for legalization of gay marriage, calling it normal marriage like everybody else, even though it's not, never will be, has missing ingredients. So it can't be real marriage. But maybe that is you. Maybe you believe that churches should be forced to do this. Explain to me why. I would I would really desperately love to try to hear a rational understanding of why you believe you have the right to tell people who have deeply held faith-based beliefs why they can no longer hold those faith-based beliefs for themselves. 888-589-8840, and if you disagree with me, you get to go to the front of the line. 888-589-8840. Let's quickly go to Ray from Virginia, who's up first. Ray, welcome. You're on AFR Talk, AFA Today. Kevin McCullough, glad you're with us.
Thank you, Kevin. I enjoy your show very much every day.
Thank you, sir.
You're very welcome. Excuse me. Apropos of the photographer and the baker, and the fact that they've had so much difficulty, it occurred to me, and I'm sure it has occurred to you, and if it hasn't, I'd like to remind you that the denial of service was a problem that we've had long ago. And please don't talk over me, if you don't mind. And that happened at a lunch counter in the South, that you could not be denied service at that lunch counter in the 60s. And the Supreme Court found that for the purpose of race, and that now has been expanded to, although I'm not certainly in favor of homosexual marriage, still the same laws apply and the same principle applies.
How is it the same principle if one is determined by behavior and the other is determined by genetics?
No, one is determined by, if the law reads either in terms of race or sexual preference. That's the way the law reads. It's very simple. And the same principle that applied at that lunch counter also applies in the provision of service, and I don't agree with it, but it also applies under the law with the provision of service for the photographer and the baker. Full stop.
But under the law, the criteria is unequal.
You may call it unequal, but the law does read for either race or sexual orientation.
Okay, now that's different. Sexual orientation is different than behavioral preferences.
Sexual orientation has been included in the findings of the Supreme Court with respect to this issue of the provision of service. The same way it did with the lunch counter for the first time in the 60s. It is today, sadly, in the teens of the next century, it is today part of the law of the land.
But you've got a constitutional case on your hands here too, because that can also violate a person's personal practice of their faith, which is a constitutionally First Amendment protected exercise.
That is not in the list of things that would lead to the denial of service, which took place, and I remind you again, in the 60s. They are two different things.
Right. You keep trying to make it about race, but it's not about race. I mean, it's not an equivalent to race. And whether the law says it or not doesn't mean we can't challenge that law and shouldn't challenge that law in court.
Challenge away. The fact of the matter is, today, it has not been successfully challenged, and so therefore the denial of service cannot be understood nor underwritten. Simple.
So what do they have the right to do to you, Ray, if you say, I'm just not going to do the wedding?
That's up to the courts.
Say that again?
I said that is up to the courts.
Okay. Yeah, so I say take it to the courts and let's whack away at it, because and I think that we need to have more of these discussions on a regular basis with the courts, because I think the courts have gotten a little uppity for themselves. Why was sexual orientation included in such a ruling in the 1960s? That doesn't make any sense. This wasn't even on the radar screen of people in the 1960s. But, and I thought a private business was a private business. I thought you could choose to take whoever you want. I don't have to take every client that comes through our door for service. I don't. It's interesting. We'll have to study up on that just a touch more. But here's the issue. Will churches start to be sued shortly? See, under the argument that Ray was just making, I don't know how you could stop them from forcing them to carry a wedding ceremony that they didn't wish to. If that is in fact the law, let's talk about it. 888-589-8840. Stay with us. This is AFA Today on AFR Talk.